Um, so today we want to talk about personal use of county-owned equipment or any public property. Some of the things we're going to talk about, we're going to review some of the prohibitions under the statutes, some of the limitations and requirements when you do have access to the county property for what could be considered a personal use. And in Utah, all of this is related to the ethical behavior of public employees. So we're going to talk about the ethics laws in the state of Utah. I know I was here not too long ago and did the full ethics training for you. So for those of you who had to sit through that, some of this will sound familiar. For others, don't hesitate to ask questions. But again, today we're going to focus on personal use of public assets. Because they're not all in one place in Utah statutes, we'll talk about several different things that prohibit the use of personal use of county equipment. And I'll try and make sure that you are aware of where that's coming from so that you can make that decision of whether or not you want a chance using county property for personal use or not. With all of that, in Utah, unlike other states, every other state I've worked in before had a very clear statute that said that a person using publicly owned equipment for personal use was a crime. And if you were a public employee doing that not only would you be charged with the crime for that use of the public equipment, you would also lose your job. Here in Utah, the legislature either has decided they were going to use a different method to get to that prohibition, or they just haven't thought about making it more clear in the statute. I know that based on some audits that the state auditor's done that I've seen and some of the conversations I've had with his staff, I think that they are looking towards having this made much more clear in the statute and making it a very clear prohibition. Right now, the thing that prohibits you from doing this, unless the county has its own very clear policy that you may not use county equipment for personal use, if that isn't there from a state basis, they use the Ethics Act as the way for persons to complain that it's not right that you're using their equipment that they've paid their county tax dollars for your personal use. And here's how that works. Again, the different areas that create this situation is more specifically the County Officers and Employees Disclosure Act, which is in Title 17, the counties section of the Utah Code. There's also some case law on these issues, and there are some IRS requirements that also come into play here, and how the IRS requires an employer of any type, but also government agencies, to treat employees using equipment and the tax implications of that use. Again, there's state auditor concerns there that we'll talk about today, and there's also some safety concerns. So, of course, the guy from the insurance group is always want to make sure that we're considering the safety concerns, right? Again, that's not meant to be exhaustive. They're, the Utah statutes are not, haven't been recodified in a long time. So they have different things that affect the behavior of public employees scattered throughout the code. So there may be other things that get to this issue as well, but these are the ones that I've found that are most clear in your use of county equipment. So when we look at the County Officials Disclosure Act, which it's kind of a misnomer. For counties, they call it the Disclosure Act. There's a similar statute that reads almost word for word in the city code, and that's called the City Ethic or Municipal Ethics Act. There's also another statute that reads very similar but is a little bit more restrictive, that is the State Employees Ethics Act. So even though they don't call it that, this is the county's Ethics Act. And the primary, there are 3 prohibitions there in the, things that you absolutely cannot do as a county official or county employee in that act. Then it goes on to all the disclosures, the things that you can do but you have to give disclosure of. One of those prohibitions of the 3 is that an elected official, appointed official, or employee of any county body may not use or attempt to use their official position to secure special privileges or exemption for himself or others. Now, when you read that really broadly, as some attorneys and judges do, you're being able to use a piece of county equipment that not all members of the public have available to them to use. Would that not be a special privilege? Especially if you're using it without any cost or fee. And so that's the prohibition that I am concerned about, you being held to task that you violated this act by using that county equipment that isn't available to the general public. Or if you used it for free, the general public has to pay for it. So that's the primary basis for the thing that can get you in the most trouble here. And we talk about this. We'll go through the process. Now, other than the state auditor or your own county auditor, no one's really charged with watching for this. But you know as well as I do, the people who watch over your shoulder the most are the people out there, not inside the courthouse, but outside the courthouse. The people who want to make sure that their tax dollars are being spent efficiently and effectively, not being misused. So any registered voter that both lives and pays taxes in this county can file a complaint against you if they think that you've misused public equipment. Use it for your own personal use. Any registered voter. And they don't even have to live and pay taxes in the county. If 2 registered voters who just live in the county and for some reason don't pay taxes, up north here that doesn't make sense, but believe me, down south with the reservations it does. Or 2 registered voters that pay taxes or fees in the county. They don't have to even live in the county. But if they own a piece of property and they're paying taxes or fees to a special service district within the county, those 2 people then can file a complaint against you. So there's a lot of eyes watching you. At least one of the complaints have to have actual knowledge of the facts and circumstances supporting the alleged allegation. So that's one thing that someone can't file a complaint who heard that you were using a piece of equipment from their brother's fiance's cousin. It has to be someone who actually saw you use that equipment. That doesn't mean do it in the dark of night. But they have actual knowledge that you used that equipment. So they saw you, there's some form of record of you using that equipment. There's a video of you. You were using it in an area that had a camera available to them, something along those lines. So just consider that, who's policing you. Those persons would make a complaint to the County Ethics Commission if the county has created their own ethics commission here in Box Elder County, which your commissioners have not created a separate county ethics commission, which is fairly common yet throughout the state. Because they haven't, though, those complaints would go to the Political Subdivisions Ethics Review Commission, which is created by statute. It is a state agency, and there have been just a couple of these types of ethics violations that have gone before this group, and they are extremely strict on these issues. Very, very strict on them. So much so that the counties that have created their own ethics commission, they've done that because they don't want to subject their employees to this statewide commission. They want people who have a better understanding of how things work in their county, how, that there are other reasons, things of that sort, and take a little bit. Yes, Jeff.
Who typically sit on those commissions, or what individuals would make that up?
They're appointed by the governing body of the county. Typically, the counties that have created them will either use a body similar to what the state has created. It's some former elected officials, no current elected officials, and some people from the public. If you've got a person that is well known to be very active in the Taxpayers Association, something like that, so that you're getting an even balance of people on that body. The problem with that myself and many of the county attorneys have had with the state commission that is structured that way is, while they certainly are diverse in their thoughts, that means that they don't come to very good conclusions, because they're not trying to come to the facts and what should happen based on the law. They're trying to mediate the situation. A couple of them want to roast the person in public, on a spit in the town square. Another person just thinks there's nothing happened here. Just why are we even talking about this? And so they decide that they're going to come somewhere in the middle. And that's not the way that these bodies are supposed to work under the statute. They are supposed to review the facts, determine whether or not a violation of the law occurred, and then make appropriate recommendations based on that. And they're limited in the recommendations they can make. That's the other problem that we've had with the state-run commission, is they come up with these recommendations that they give to the county for action that they're not authorized under the statute to provide. So the second answer to your question is, many counties that have created these have hired an administrative law judge or a retired judge, someone who understands the law and is used to doing what the statute prescribes. Look at the circumstances, look at just the facts of the circumstances, and make a determination of whether or not the law was violated or not. And then, within the scope of your authority, make recommendations. If you're a merit employee, so not an elected official, not an appointed official, you're under the merit system, then under those circumstances, you would go in front of the merit commission rather than either of these ethics commissions, which, again, you may think that's good because you're not dealing with the ethics commission itself, but again, what are you comfortable with the result you'll get from the merit commission, who will really be thrown for a loop with this? They've never done, this area of the law would be completely unfamiliar to them. So I'm not sure what the outcome would be in front of that group. The other problem with this is, while the statute lays this out, that this is who these types of complaints of violations of the Ethics Act are sent to, and has pages and pages of statutes of how that whole process goes, how the hearings are conducted, because right now, if a complaint was filed against you with the state commission, they can subpoena you, they can subpoena all of your records, cell phone information, emails, all of that sort of thing. They can hold you in contempt and make you pay money or go to jail for not answering their requests. They have a very wide or broad ability and power when it comes to holding these investigations. The problem that we've been running into throughout the state is people don't always use this process. They'll go to a local county attorney or a city attorney, a city police department, a county sheriff's office, and make the complaint there, and they'll start an investigation. and you're being investigated for something, sometimes without even your knowledge, and if with your knowledge, you're on your own. Because the problem that many of the county attorneys have with this statute is one of the penalties that we'll see is that this is a misdemeanor if you violated this. And they will get a recommendation from this commission whether or not criminal charges be filed. And so if they have to file criminal charges against you for this potential violation, it's a conflict of interest for them to provide any assistance to you while you're under investigation and while you're in these hearings. So you're going to be left that if you want to be represented by legal counsel while you're in these hearings and while you're being investigated, that will be on your own, at your own cost. And again, we have a real concern with that. When there's a statutory provision and process to be able to handle these, that should be used. But actually more of the complaints of these types of ethics violations that we've seen in the last 2 years have been being reviewed and investigated by local authorities and not by the state commission. And when I've approached leaders in the legislature who crafted this whole section of the statutes and explained that and said, we'd like to make this so that there's all of these complaints are going to one place, the response I got back was, no. They're a government employee, they're a government elected official, they're a government appointed official. We need as many different ways to keep watch over them as possible. So yeah, if people want to go to the commission we've created, that's fine. If they want to go to the local police department, that's fine. And if they want to go to both, or to 3 or 4 different places to have it be investigated, that's all fine. We don't agree with that at the association or at UCIP. We'll continue to work at that, but right now the legislature is not open to curbing that problem of having lots of different people potentially be looking at this. Again, if a county has created their own local commission, that commission is the primary review authority, so somebody, that's one limitation on what I was just talking about having it several different places. At least the statute says if there's a local commission, that if the state commission receives a complaint, they must send that complaint back down to the county commission. That's been created, they cannot hear that. But even speaking with the Attorney General assigned to, Deputy Attorney General that's assigned to that commission, she pulls her hair out that they like to do things and whether or not they actually have statutory authority to it. So we'll wait to see if they actually would do that, if they actually would just wash their hands of it and send it back. I'm concerned that they might not. So any questions on who reviews the complaints? The other thing is, if there's a county commission created and a violation has been reviewed by them, that's the end of it. The state commission cannot hear something that's already been heard by the local county commission. Okay? So that limits the potential for problems for you here. There's a couple of other limitations on what ethics commission can hear. They cannot hear a complaint against a former officer or employee. So that's always one great way to get out of dealing with this is if somebody complains about you, you can just resign. That's probably not a good answer, though, for most of you, right? Except for a few of the gray hairs that maybe. We'll get to that problem in a bit here. The commission cannot hear or must dismiss if criminal charges are filed. So if the violation is such that a prosecutor, whether it's city prosecutor, county prosecutor, state AG's office, whoever it is, charges you with a crime, hey, that's good news. You're not going to be reviewed by the Ethics Commission. I don't know that that's really a good way to get around it, though. So the penalties. In addition to any other provision of laws, the way that the statute reads, so if there are other places in the statutes that you can be penalized as well, you can be penalized there, but specifically under the Ethics Act, you shall be removed from office or employment, and it's a Class A misdemeanor for using your position to, for special privilege. That's what the penalty is. And of course, we're just talking about personal use of county equipment today, but just keep that in your mind anytime you are using your position as a county official or employee for special privilege that others don't have, you're in violation of this ethics law. So if you need your child's birth certificate, and you know that you can go on the computer and type that thing up and have it spit out, don't do it. Go through the normal process that every other person from the public goes through. Go on the other side of the desk, fill out your form, pay your $5, get your kid's birth certificate, and you will not have violated this. But if you take the shortcut, you violated this, you might lose your job and have a Class A misdemeanor filed against you. I said you could retire potentially and not have to deal with this if you're at that point, but here's another problem. The state code, chapter 4911-1401, which is called Forfeiture of Retirement Benefits for Employee-Related Offense Convictions. If you violate the Ethics Act, and if you are charged with the misdemeanor, and if they find that you did violate and that you are convicted of that misdemeanor, all of the employee URS benefits that the county has paid into your retirement fund for all the years you've worked for the county go back to the county, and you lose them. The only thing you have left in your retirement is stuff that you, by choice, put into your 401k, and because you don't pay the pension portion of the benefits in the URS. So that probably is the worst piece of the penalty of all, right? So again, that's one that some people don't think about that could really make or break how you move on in life past the county if you're charged with this. And that statute has been implemented several times that I know of just in the last couple of years, typically because the state auditor's office sees these things going on, they keep an eye on it, and then when they see that somebody has been charged with a crime that they committed in their office, either as an official or an employee, they're pushing that those benefits need to go back to the taxpayer and cannot be given to that employee. Okay? Am I the bringer of great news or what? You guys always ask me up here to do these fun trainings. So that ethics commission, again, if whether it be the state or a local one, for violations of the act, they make recommendations on actions against the officer or employee back to the governing body of the county. The governing body, the statute says they must review them. So most governing bodies that get them will review them in a public meeting. So it's on the record at open public meeting that this ethics commission has recommended certain actions be taken against you. And if you read the statute literally, that commission is supposed to either find that there's a violation, that there wasn't a violation, and then it should be done. They shouldn't even be making any recommendations to the county at that point at all. It's just over if there was no violation. However, the couple of times that they have met and have done hearings, even though on several different items they found that there was no violation, they thought that the behavior was such that they needed to make some recommendations and there had to be some type of discipline provided. So they made recommendations that are outside the scope of what they're supposed to be saying, which, yeah, you may be able to get those reversed if you spend a lot of money to have your attorney fight that, but a lot of the damage has been done. That's all been done in open public meetings, and again, you've had to have an attorney to help you to get past that. What they're supposed to recommend under the statute, what they have the authority to, is that there's been a violation, and therefore the employee shall be removed from employment. And that's the way the statute reads. It is not a choice that the county commission has, or HR has at that point. You shall be removed from office or employment. And I have shall there in quotes, simply because when we're talking about an employee or an appointed official, that's not a big deal. The issue that comes up is when we have an elected official who has violated the act, and the statute says they shall be removed from office, but as we all know from the Salt Lake County assessor situation, there is no process in the state of Utah to remove an elected official from office, although there'll be more legislation this year to work out a way to be able to have that done. So the governing body of the county shall remove that person from office, and then they also, the statute says they shall send a recommendation of consideration of the criminal violation to the county or district attorney within the jurisdiction. So they would make, in most cases when this happens, the county simply sends to the recommendations from the commission to the county attorney with their position that we need you to review this and make your determination of whether or not you think this is a prosecutable crime and move forward with it under your discretion. So it will be up to the county attorney whether or not you are actually charged with the crime. All right, so that's the not so good news, right? Are there questions yet at this point? You're all just, okay. Just a couple of other things that seem to kind of come into play when we have these situations come up. Under that Title 17 Ethics Act, there's also a prohibition against any person inducing or seeking to induce an appointed or elected officer to violate any of the provisions of that code. So if you try and, you've been using the county equipment from time to time, and you don't want to be the only one in the office that's been doing that, so you try and convince others that they should be doing it too because it's a county perk and let's do it. If we're all doing it, they can't stop us, right? You've committed another section, a violation under another section of the code. And again, it doesn't just need to be a coworker like that. If someone in the public is saying, hey, you know what? The two of us should get should do some work on the trees that border our two properties this weekend. Can you use the county pruner? Can you get that thing and we can use that? But actually, that person has violated this act and could be charged as well for the crime under the act for having induced you to violate the act.
Even if they don't cut the tree? If they don't do it?
It says induce, seek to induce. So if somebody ever has that conversation with you, say, stop. You don't want to be asking me to do that. This is a huge no-no, and I don't even want to have that conversation. Can't do it.
Can you elaborate a little on use of county property? I mean, if I call my kids from the phone?
We're going to get to that.
Okay.
Because that, of course, I can't believe it took this long for somebody to ask me
You're
that.
scaring all of us to death.
When I do the silver at the sheriff's office in a couple hours, I won't make it through my title slide, and they'll be asking me that question. So, yeah, that's the big part of the discussion. And remember, this applies to any section of the Ethics Act. So one of the other huge prohibitions in the Ethics Act is your use of protected records of the county for anyone else's use, taking records that are protected from the county. not using the grandma procedure to make a request for those records, and you take them and you are getting them to provide to a second employer who knows that you have access to the county records, or you're going to use them for your own personal use. Those are also strictly prohibited. So again, anybody that tries to induce you to get those records and take them not using the appropriate process is violating this section of the statute as well. So there have been a couple of cases that the courts have looked at the issue of use of public assets, and all the way up to the Utah Supreme Court and the appellate courts, they've clarified that a public agency may not give a public asset of any type to a person without reasonable compensation. So again, when you read that in attorney speak, in court speak, the county cannot give someone money, they cannot give them use of equipment, they cannot give them special privilege of any type without being compensated for it. So again, if they're allowing an employee to use equipment that has no benefit to the county, that use has no benefit to the county, and they're doing that and they're not getting some reasonable compensation for it, the case law would say you violated the law as well. Or not you, the county's violated the law by allowing you to do that. So now not only are you in trouble, the county's in trouble too for allowing you to use that equipment. The way that the courts say that there can be exception made is that if the county can show a benefit to the county that matches the market value of the asset given or at least equal to the cost to the county. So the wear and tear on the piece of equipment that during the time that you're using it. So there are certain situations where, and again, there's a lot of language when you start looking at some of the other related things here that talk about de minimis use. So yeah, a family member calls you on the county phone and you answer it and you use it. During your lunch break, if it's allowed under county policy, because again, this is all statutory. The county policy may be different, but if the county policy allows for de minimis use of your computer to check your personal email while you're on your lunch break, something like that, okay. I think you're going to be okay with those types of situations. But it's running 1,000 copies of your save the date for your kid's wedding on the copier after hours type of thing, that's not de minimis use. And the general public doesn't have use of that copier in that manner, so you shouldn't either. So for those types of situations, I'm certain, working with the HR department, that there is policy related to, I can't remember if you guys call it usual and customary or de minimis or what your terminology is, but that some limited use of that type of county equipment, computers, phones, things of that sort is okay under the county policy. And again, I think these commissions, especially if one is created locally, that's the type of thing that they would say, hey, it's the county policy. The county's more or less telling them that that's okay. The county's, under this law, case law, the county's identified the benefit that they get of that you don't have to get up from your desk, leave the building, get out on your cell phone, and call back, all the headache that entails. So there is some benefit. Then that would be okay, right? If there are uses that go beyond just using the phone for a quick phone call, using the computer real quick for personal email that you really need to get back to somebody on, something like that, those situations that you can justify that there is some benefit to the county, that's something that you should be bringing, particularly the department heads. Bring it to your supervisor, who can then work through the department head to bring that to HR, the county attorney, and the county commission to review the policy and determine if we need to make clearer the exception to certain uses of certain county equipment and properties. Okay? Because again, in the sheriff's office, there's going to be a lot of them for public safety, I should say, not just sheriffs. Okay? All right. The IRS, I mentioned, also has some concerns here. They require that any non-de minimis value the employee receives to be reported as income for tax purposes. So again, even if the county says, okay, yeah, we can see that there's some value to letting you use the copier to make a bunch of copies, and we do have one at the library that we make available to the public, so, and we charge them a couple cents per copy, so we're going to let you use the one that here at the courthouse, but we're not going to charge you. Well, still, then the 3 cents per copy needs to be recognized as income to you that you have to pay your taxes on. Probably more of a headache than the auditor's office wants to go through, right? So there are those issues that we need to deal with, and so cell phones that are provided to you by the county, certainly vehicles that are provided by the county that you're driving when you're using them for personal use, other than, you know, certainly you pull over at the rest area to have a potty stop on your way to your meeting in Salt Lake, that's de minimis use. But if you decide that as long as I'm in Salt Lake anyway, I'm gonna, you know, I've never been out to up to Snowbird. I'm gonna drive on up there and see what that's like, and you know, check out Oktoberfest quick before I go back to my hotel room. That personal use of that vehicle, you should be identified as, if it's allowed by the policy, that needs to be included as income to you, or you would pay for the use of the vehicle to do that, one way or the other. State auditor concerns, again, the conversations I've had with people in his office are simply that they think it's a misuse of public funds to allow an employee to use any county, city, state equipment without having them pay a reasonable charge for having used that equipment. And that at the very least, that all those political subdivisions should have good policy on what is allowed, what's not allowed, and how they're going to handle all the tax implications and other implications of it if they are going to allow it. Okay. And then there's the safety concerns. You know, some of the uses that I've seen, the personal uses, have been people working in the county buildings on the weekends, and things of that sort. And some of your county buildings are remote. And if that person is injured while they're in the county facility on a weekend when there's no one else around, what happens? That could be a pretty serious situation. So that is certainly a concern. And so depending on the type of equipment that you're using, again, the copier, one thing. The brush cutter, a whole different situation, because then there's going to be all types of discussion about, well, you're an employee, but you weren't working, it was outside scope of authority, you're not going to get workers' comps, but then can you sue the county? Because they are your employer, and under the work comp laws, you can't sue your employer for an injury, you can only ask for workers' comp, and if workers' comp's denied, you still don't, so you may not get anything for that injury. But the worst part is, you're out there severely injured using the county's equipment, and there's no one there to help you or deal with that situation, potentially. Those are real concerns. And because right now, over the next, we've got about 18 months left of this, UOSH, Utah Occupational Safety and Health, has a local emphasis program where they are targeting counties and cities and other political subdivisions to come in and do safety inspections. And so if as part of a safety inspection, they see that hazardous equipment is being used for personal use outside of the work hours, that would certainly be a concern for them that they'd write up the county on. And so that's another agency that potentially could be writing a scathing report that this shouldn't be happening the way that it's happening. And lastly, I hate to say it, but there's been a few situations here where people have been accused of having done these things, and it can get pretty nasty, the discussion around that. So I just want to remind everyone that there is a specific statute in Title 76, threats to influence official or political action, that threatening any harm against a public servant, party official, or voter with a purpose of influencing their actions, decisions, opinions, recommendations, nominations, vote, or other exercise of discretion is a Class A misdemeanor. So again, if someone comes to you and says, hey, I want you to come to work for me, start taking those records that you have access to as a government employee that I can't get under grandma, and I want you to bring them to me at night to use for business, and you tell them, no, I can't do that, you shouldn't even be asking me that, and they said, I'll ruin you. You have this little business outside of the county that I'll put under, and I'll make sure that you will regret not doing this for me. They've now committed this violation of the statute. So you have some protection there, okay? Because again, harm in this setting, we usually think of threats as physical threats, right? But here it's very clear that it's any disadvantage or injury pecuniary, which means money, or otherwise, including disadvantage or injury to any other person or entity in whose welfare the public service is interested in. So even if you're not involved in that other business, it's run by your spouse, they say, well, I'm not going to give your spouse any more work for his business, which is really going to hurt them financially. That is part of the definition of harm here. Yes.
So, myself and the other people here, we went to the assessor's office in about 15 minutes. We're about to go out that much people.
Okay.
So, and maybe this is a question for Jeff here. At what point does it become, because we do get threats, not necessarily I'm going to come to your house and sleep, but where's the level of, okay, this is something I need to report, besides just, people yell at you, that's not a threat, but
Well, you might want to just direct them to this code. That I want to, I appreciate your situation. I understand that you don't agree with my assessment of the value of your property. There's a procedure to go through that, but the angry, your demeanor isn't helping here. Oh, and I just want to remind you that threatening me as a public servant is a Class A misdemeanor under the law, and if you continue to do that, I may be obligated to report this to the county attorney. Because there have been, here in Box Elder, there have been a couple death threats against county officials for trying to get them to take a specific action that the person wants them to take. So this is very real. And again, if it's meant to influence your action, lower my values or else, that's this code. If it's another threat, then you would just use the general threats against others portion of the criminal code to deal with that. Okay. And that is the end of the presentation. Are there questions? Again, if there are situations where you think that it's legitimate for you to be using county equipment, even though it may not seem to you to be personal, it might be using it outside of the normal work hours, it might be using it outside of the county jurisdiction, because believe me, when people see a car with the Box Elder County logo on the door, down on the Wasatch front, and especially when it's parked at Costco or something like that, they really wonder if that's really being used for the purposes that it's supposed to be being used for. So if you have any of those types of situations that you know will happen in your department, let's work through the process to make sure that the county policy recognizes that and makes reasonable consideration for that. I'm not telling you that the county will authorize all of those situations, but at least we can have the discussion. And because again, the county will need to be able to legitimize what is the benefit to the county. All right? Great. If you have questions that you're too embarrassed to ask in front of the whole group, Diane and Jenica have my number. Don't hesitate to give me a call directly. I'll be happy to help you out. Because we really appreciate the work that you do for the county and for the taxpayers of Box Elder County. And so I know seems like a lot of doom and gloom, but I don't want any public employee to think that it's not worth doing the work because of things like this. We will be there to help you as much as we can to keep you out of trouble. And that's why I'm here this morning. So thank you very much for your time.